the learning outcomes. We would be able to learn about all the acts under IPC, that is the Indian Penal Code, understand the importance of Indian Penal Code, know the punishments act-wise under IPC, discuss and evolve our thinking towards law. First, we will start with an introduction to Indian Penal Code. Indian Penal Code is the main criminal code of India, intended to cover all the aspects of criminal law. The Indian Penal Code lays stress upon the following says: Actus Reus reum nisi mens sit rea. This we had covered in some of the last module also. Actus reum nisi mens sit rea, which means actus reus, guilty act, and mens rea means guilty mind. The Indian Penal Code was established in 1862 in India and is not applicable to the state of Jammu and Kashmir. Based on IPC, Jammu and Kashmir has enacted a separate code known as Ranbir Penal Code, which is known as RBC. For a society to function peacefully, it is important that first, each citizen is equal and no citizen is above the law. Second, in the uncivilized society, no person was said to be safe from attacks of his personal belongings or property by any other person. Third, the person who were attacked by criminals in olden days either succumbed or were overpowered by his opponent. Fourth, a tooth for a tooth, an eye for an eye, a life for a life was the rule of law. With the advancement of time, the injured person agreed to accept the compensation instead of killing. For a long time, the function of settling the terms remained with the parties themselves, but gradually this function came to be performed by the state. Penalizing the defaulters started long before IPC as a code of conduct came into existence. In India, the criminal jurisprudence came into existence from the time of Manu, has recognized assault, theft, robbery, false evidence slander, criminal breach of trust, cheating, adultery, and rape. The king protected his subjects. The subjects in return owed him allegiance and paid him revenue. The king administered justice himself. If unable due to certain circumstances, the matter was entrusted to a judge. If a criminal was fined, the fine went to the king's treasury and was not given as a compensation to the injured party. Different laws came into existence in the reigns of different rulers. When the British came into India, they adopted a different set of law, which was based on British pattern, but it was not uniform throughout India. Different regulations were passed prescribing practice and procedure to be followed. Now, the making of the IPC. In 1834, the first Indian Law Commission was constituted to investigate into the jurisdiction, powers and rules of the existing courts, as well as police establishment and into the laws in operation in British India. The Indian Penal Code was drafted by the first Indian Law Commission under the presidentship of Thomas Babington Macaulay and was submitted to the Governor General of India in Council in 1837. It was circulated to the judges and law advisors of the Crown. In 1845, another commission was appointed to review this code. This commission submitted its report in two parts, one in 1846 and the other in 1847. The code was revised according to the report of the commission, but it never saw the light of the day. Subsequently, it was revised by the two law members of the Governor General of India in Council and was presented to the Legislative Council in 1856. However, it did not apply automatically in the princely states, which had their own courts and legal systems until the 1940s. The code has since been amended several times and is now supplemented by other criminal provisions. The structure of IPC, that is the Indian Penal Code. The Indian Penal Code of 1860 is subdivided into 23 chapters, comprises 511 sections. The code starts with an introduction, provides explanations and exceptions used in it, and covers a wide range of offences. Chapter 1 deals with introduction, Chapter 2 with general explanations, Chapter 3 with punishments, Chapter 4 general exceptions, Chapter 5 abetment, Chapter 5a criminal conspiracy, Chapter 6 offences against state, Chapter 7 offences related to army, naval and air force, Chapter 8 offences against public tranquility, Chapter 9 offences by or related to public servants, Chapter 9a offences related to elections, Chapter 10 contempt of lawful authority of public servants, Chapter 9 false evidence and offences against public justice, Chapter 12 offences relating to coin and government stamps, Chapter 13 offences relating to weight and measures, Chapter 14 offences affecting the public health, safety, convenience, decency and morals, Chapter 15 offences relating to religion, Chapter 16 offences affecting the human body, Chapter 17 offences against property, Chapter 18 offences relating to documents and property marks, Chapter 19 the criminal breach of contracts of service, Chapter 20 offences relating to marriage, Chapter 20a cruelty by husband or relatives of husband, Chapter 21 defamation, Chapter 22 criminal intimidation, insult and annoyance, Chapter 23 attempts to commit offences. First chapter, which is the general principles, operation of the provisions, territorial, provisions applicable to offences committed within India, extra-territorial, provisions applicable to offences committed by citizens of India outside India, and offences committed on ship and aircrafts registered in India. Likewise, for these offences under IPC, punishments are divided under two heads. For offences committed within India, punishment of offences committed beyond the territory but which by the law may be tried within India. Every person shall be liable to be punishment under this code and not otherwise for every act or omission contrary to the provisions thereof, of which he shall be guilty within India. Any person liable by any Indian law to be tried for an offence committed beyond India shall be dealt with according to the provisions of this code for any act committed beyond India in the same manner as if such act had been committed within India. Now, extension of code to extraterritorial offences. The provisions of this code apply also to any offence committed by any citizen of India in any place without and beyond India, any person on any ship or aircraft registered in India wherever it may be. Now, the explanation of this. In this section, the word offence includes every act committed outside India which, if committed in India, would be punishable under this code. Now, an example, a person, for example, who is a citizen of India commits some murder in Uganda. He can be tried and convicted of murder in any place in India in which he may be found. Now, certain laws not to be affected by this act. Nothing in this act shall affect the provisions of any act for punishing mutiny and desertion of officers, soldiers, sailors or airmen in the service of the government of India or the provisions of any special or local law. The general part of criminal law deals with principles and doctrines. This includes the principles of criminal liability, defences to criminal liability, rules relating to punishments and doctrines governing preliminary crimes. On the other hand, the special part of criminal law deals with specific crimes. This includes rules defining individual crimes and prescribing punishments for them that apply the general principles and doctrines to particular crime. Now sections 1 to 120b. Whoever is a party to a criminal conspiracy to commit an offence punishable with death, imprisonment for life, or rigorous imprisonment for a term of 2 years or upwards shall, where no express provision is made in this code for the punishment of such a conspiracy, be punished in the same manner as if he had abetted such offence. Now some specific offences, sections 121 to 510. Criminal law has its aegis laid on the following principle: there can be no crime without a guilty mind. That is, the liability of a crime is expressed by the Latin phrase Actus Reus non fecit reum nisi mens sit rea, which means an act is not culpable unless the mind is guilty. Owing to the above statement, a crime is studied under two heads, Actus Reus and mens rea. Actus Reus, or the guilty act, as an element of criminal responsibility, the wrongful act or omission that comprises the physical components of a crime. Criminal statutes generally require proof of both Actus Reus and mens rea on the part of a defendant in order to establish criminal liability. Next is mens rea, or the guilty mind. Most crimes requires lawyers or attorneys. These referred to as mens rea, which is a Latin word meaning a guilty mind. Mens rea under IPC. No mention made, but doctrine incorporated in two ways. Mens rea included in the definition of the offence through terms like dishonestly, fraudulently, voluntarily, intentionally, knowingly. Concept included in the provisions relating to general exceptions in chapter 4. When the definition does not include mens rea, it means that the liability is strict. Second chapter of general explanations. Chapter 2, general explanations of IPC. Definitions in the code to be understood and are subject to exceptions. Throughout this code, every definition of an offence, every penal provision, and every illustration of such definition or penal provision shall be understood subject to the exceptions contained in the chapter entitled General Exceptions, though these exceptions are not repeated in such definition, penal provision, or illustrations. Illustrations: the sections in this code which contain definitions of offences do not express that a child under 7 years of age cannot commit such offences, but the definitions are to be understood and are subject to the general exception which provides that nothing shall be an offence which is done by a child under 7 years of age. For example, A, a police officer without warrant apprehends Z, who has committed murder. Here, A is not guilty of the offence of wrongful confinement, for he was bound by law to apprehend Z, and therefore the case falls within the general exception which provides that nothing is an offence which is done by a person who is bound by law to do it. Section 6 to 52A. Interpretation clause giving definitions of various terms in the code for the purpose of the code. Examples are dishonestly defined under section 24, counterfeit defined under section 28, injury defined under section 44, good faith defined under section 52. Now chapter 3, which deals with punishments under IPC. Section 53A, construction of reference to transportation. Subject to the provisions of subsection 2 and subsection 3, any reference to transportation for life in any other law for the time being in force or in any instrument or order having effect by virtue of any such law or of any enactment repealed shall be construed as a reference to imprisonment for life. Second, in every case in which a sentence of transportation for a term has been passed before the commencement of the Code of Criminal Procedure Amendment Act 1955, 26 of 1955, the offender shall be dealt within the same manner as if sentenced to rigorous imprisonment for the same term. Third, any reference to transportation for a term or to transportation for any shorter term by whatever name called in any other law for the time being in force shall be deemed to have been omitted. Fourth, any reference to transportation in any other law for the time being in force shall a. If the expression means transportation for life, be construed as a reference to imprisonment for life. B. If the expression means transportation for any shorter term, be deemed to have been omitted. Section 54. Commutation of sentence of death. In every case in which sentence of death shall have been passed, the appropriate government may, without the consent of the offender, commute the punishment for any other punishment provided by this code. Section 55. Commutation of sentence of imprisonment for life. In every case in which sentence of imprisonment for life shall have been passed, appropriate government may, without the consent of the offender, commute the punishment for imprisonment of either description for a term not exceeding 14 years. Section 55A, which gives the definition of appropriate government. In sections 54 and 55, the expression appropriate government means A. In cases where the sentence is a sentence of death or is for an offence against law relating to a matter to which the executive power of the Union extends the central government, and B. In cases where the sentence, whether of death or not, if for an offence against law relating to a matter in which the executive power of the state extends the government of the state within which the offender is sentenced. Section 56. Sentence of Europeans and Americans to penal servitude, provision as to sentence for term exceeding 10 years but not for life. Repealed by the Criminal Law, Removal of Racial Discrimination Act 1949, 17 of 1949, which came into effect from 6th of April 1949. Section 57. Fractions of terms of punishment. In calculating fractions of terms of punishment, imprisonment for life shall be reckoned as equivalent to imprisonment for 20 years. Section 58. Offenders sentenced to transportation, how dealt with until transported. Repealed by the Code of Criminal Procedure Amendment Act 1955, 26 of 1955, Section 117 and scheduled with effect to 111956. Section 59. Transportation instead of imprisonment. Repealed by the Code of Criminal Procedure Amendment Act 1955, 26 of 1955, Section 117 and scheduled with effect from 111956. Section 60. Sentence may be, in certain cases of imprisonment, wholly or partly rigorous or simple. In every case in which an offender is punishable with imprisonment, which may be of either description, it shall be competent to the court which sentences such offender to direct in the sentence that such imprisonment shall be wholly rigorous, or that such imprisonment shall be wholly simple, or that any part of such imprisonment shall be rigorous and the rest simple. Section 61. sentence of forfeiture of property, repealed by the Indian Penal Code Amendment Act 1921, 16 of 1921, Section 4. Section 62, forfeiture of property in respect of offenders punishable with death, transportation or imprisonment, repealed by the Indian Penal Code Amendment Act 1921, 16 of 1921, Section 4. Section 63, amount of fine. Where no sum is expressed to which a fine may extend, the amount of fine to which the offender is liable is unlimited but shall not be excessive. Section 64, sentence of imprisonment for non-payment of fine. In every case of an offence punishable with imprisonment as well as fine, in which the offender is sentenced to a fine whether with or without imprisonment, and in every case of an offence punishable with imprisonment or fine, or with fine only, or in which the offender is sentenced to a fine, it shall be competent to the court which sentences such offender to direct by the sentence that in default of payment of the fine, the offender shall suffer imprisonment for a certain term, which imprisonment shall be in excess of any other imprisonment to which he may have sentenced or to which he may be liable under a commutation of a sentence. Next is Section 65, limit to imprisonment for non-payment of fine when imprisonment and fine are awardable. The term for which the court directs the offender to be imprisoned is dealt of payment of a fine shall not exceed 1/4 of the term of imprisonment, which is the maximum fixed for the offence, if the offence is punishable with imprisonment as well as fine. Next is Section 66, description of imprisonment for non-payment of fine. The imprisonment which the code imposes in default of payment of a fine may be of any description to which the offender might have been sentenced for the offence. Section 67, imprisonment for non-payment of fine when offence punishable with fine only. If the offence be punishable with fine only, the imprisonment which the code imposes in dealt of payment of the fine shall be simple, and the term for which the code directs the offender to be imprisoned in fault of payment of fine shall not exceed the following scale. That is to say, for any term not exceeding 2 months when the amount of the fine shall not exceed 50 rupees, and for any term not exceeding 4 months when the amount shall not exceed 100 rupees, and for any term not exceeding 6 months in any other case. Section 68, imprisonment to terminate on payment of fine. The imprisonment which is imposed in default of payment of a fine shall terminate whenever that fine is either paid or levied by process of law. Section 69, termination of imprisonment on payment of proportional part of fine. If before the expiration of the term of imprisonment fixed in default of payment, such a proportion of the fine be paid or levied that the term of imprisonment suffered in default of payment is not less than proportional to the part of the fine still unpaid, the imprisonment shall terminate. Now an illustration. A is sentenced to a fine of 100 rupees and to 4 months imprisonment in default of payment. Here, if 75 rupees of the fine be paid or levied before the expiration of 1 month of the imprisonment, A will be discharged as soon as the first month has expired. If 75 rupees will be paid or levied at the time of the expiration of the first month or at any later time while A continues in imprisonment, A will be immediately discharged. If 50 rupees of the fine be paid or levied before the expiration of 2 months of the imprisonment, A will be discharged as soon as the 2 months are completed. If 50 rupees be paid or levied at the time of the expiration of these 2 months or at any later time while A continues in imprisonment, A will be immediately discharged. Section 70, fine leviable within 6 years or during imprisonment, death not to discharge property from liability. The fine or any part thereof which remains unpaid may be levied at any time within 6 years after passing of the sentence, and if under the sentence the offender be liable to imprisonment for a longer period than 6 years, then at any time previous to the expiration of that period, the death of the offender does not discharge from the liability any property which would after his death be legally liable for his debts. Apart from these, the other general forms of punishments under IPC are as indicated below: flogging, mutilation, branding, pillory, security bond, banishment, penal servitude, solitary confinement, imprisonment for life, and capital punishment. Next is chapter 5, which is abetment, section 107 to 120. Instigating the commission of an offence, engaging in conspiracy and doing an act towards committing an offence, intentionally aiding in the commission of an offence. Next is chapter 6, general exceptions. It covers sections 76 to 106. It includes exceptions such as private defense, act by child below 7 years of age, act done in good faith, communication made in good faith although without the consent, etc. Next is chapter 5A, which is criminal conspiracy, section 120A and 120B. When more than one person agree to do an illegal act or a legal act by illegal means, it is criminal conspiracy. What are the classes of offences under this? Offences against property, section 378 to 462, theft, extortion, robbery, dacoity, criminal misappropriation, criminal breach of trust, cheating, mischief and trespass, offences relating to documents and property marks, section 463 to 489, E, forgery, criminal breach of contract of service, section 490 to 492, offences relating to marriage, section 493 to 498, like adultery and bigamy, cruelty by husband or relatives of husband, section 498A, defamation, section 499 to 502, and criminal intimidation, insult and annoyance, section 503 to 510. Next is decriminalization of section 309. Decriminalization of section 309. The section 309 in the Indian Penal Code lays down the punishment for attempted suicide. The maximum punishment can be awarded is imprisonment for a term of 1 year. There has been appeals to remove the section from different sources. In the Gyankor case in 1996, a 5-judge bench of the Supreme Court of India had ruled that the section 309 was not violative of Article 21 of the Constitution of India. The Law Commission of India had also recommended removal of the section from the statute. Definition: attempt to commit suicide. Whoever attempts to commit suicide and does any act towards the commission of such offence shall be punished with simple imprisonment for a term which may extend to 1 year, or with fine, or with both. Section 309 of the Indian Penal Code is said to be limited in effect by the Mental Health Care Bill 2013. The Mental Health Care Bill was introduced to the Rajya Sabha on August 19, 2013 and provides in Article 124 that notwithstanding anything contained in section 309 of the Indian Penal Code, any person who attempts to commit suicide shall be presumed, unless proved otherwise, to be suffering from mental illness at the time of attempting suicide, and shall not be liable to punishment under the said section. It also provides that the government shall have the duty to provide medical care to any such person attempting suicide. This bill therefore does not repeal section 309 of the Indian Penal Code, but merely provides the presumption of mental illness. Now we will conclude with the summary. After studying this module, you must have learnt about the setup and functioning of the Indian Penal Code of India, know about the different chapters listed under IPC and their specific sections. Also, you will know about the different punishments set for different offences.